Good evening, everyone. It's a Just Talk discussion today, and I believe there's nobody these days who would disagree that this topic is very relevant. We will be discussing a crime of aggression today, and not through the lens of emotions, political declarations. We will do our best to be very practical about what a legal community sees as its task, which approaches exist as of now, and which types of solutions of accountability for crime of aggression which actually became manifested through events of yesterday and today for the entire world. And I'm convinced that every one of you keeps receiving calls and messages from the entire world asking how you are doing, what is happening. And we say they won't see us give up, and we continue working. So in this next 2 hours, let's try and talk about what we as lawyers are working on, what approaches we have, why it is so important to make sure the perpetrators are held accountable for the crime of aggression, why precedent is so important. Precedent that can not only change the situation in Ukraine but elsewhere. We'll try to take a view at it from different perspectives. And our discussion today is transferring the matter from political dimension into a very practical one. And I'm very grateful for this opportunity to have such wonderful speakers with us today. They will introduce various solutions that are available to us, the solutions that already exist. We'll try discussing their pros and cons, weaknesses and strength. But aside from that, we also have an opportunity to discuss a very interesting document that you can see in front of you. We made sure to translate it into Ukrainian. It is available at Just Security blog. It was made public, I believe, in May. And the Open Society initiative, our partners paid a lot of effort to make sure that crime of aggression does not look as something very distant, something abstract. They tried to translate it into a language of law. We have a model document about crime of aggression that was drafted by Open Society Justice Initiative. And I would like to give the floor to the head of the initiative, James Goldstone, for him to introduce the document and to share why this document was drafted, why it was publicly presented, and what value does it have, and what its content is. And I hope that in the course of our discussion, we'll be able to elaborate on this matters in more detail. James, over to you.
Great, thank you. So thank you very much, Roman. Thank you all for being here. I want to say what a privilege and honor it is to be here in Kyiv with you on these very days when the results and manifestations of aggression are being experienced in this capital and across this country. I want to focus my remarks on just 3 questions, and just to say I'm doing so as the director of the organization, Open Society Justice Initiative, which produced this model indictment. My own background is partly in the field of criminal prosecution, both in the United States and at the International Criminal Court. I want to first address the question of why one would prosecute aggression. It may seem obvious, but I think it's important to note Secondly, what is the crime of aggression and who might be charged? And thirdly, to touch on the question of in what forum or fora might the crime of aggression be prosecuted, and my colleague Eric Witte will elaborate further, I think, on the range of options that might exist with respect to that. So there are many reasons to prosecute aggression, but let me highlight three. First, because aggression is, as the Nuremberg Tribunal so famously stated, the supreme international crime, which contains within itself the accumulated evil of the whole. As in World War II, so in Ukraine today, the initial aggression has made possible all the subsequent suffering, criminality, and loss of life and property that we've witnessed. A second reason to prosecute this aggression is because Russia's unprovoked invasion and attempt to subjugate Ukraine is not just any aggression. It constitutes the clearest and most egregious instance of the crime of aggression in decades. And it is an attempt to extinguish the state of Ukraine and annex its territory. And finally, aggression here should be prosecuted because doing so is actually not terribly difficult. Indeed, proving the culpability of senior leaders under the crime of aggression is far more feasible in certain ways than it may be for war crimes or crimes against humanity. The crime of aggression, as you will know, is by definition a leadership crime. And the evidence of the Russian leadership's criminal culpability is already clear. And in fact, in order to show how clear, we published earlier this year this model indictment that you have against President Putin and 7 other senior Russian leaders. Our view is that investigation for the crime of aggression would complement and not replace concurrent investigations and possible prosecutions for war crimes and crimes against humanity. And while those investigations for war crimes and crimes against humanity often start with those in the field directly responsible and try to move up the chain of responsibility, an aggression investigation starts and generally will end with senior leadership. So let me turn now to the questions of what exactly is the crime of aggression and who might be charged. Aggression is, of course, a crime in a number of national jurisdictions, including in Ukraine. However, the definition of aggression that would seem to have the greatest international legitimacy at present is contained in Article 8 bis of the Rome Statute of the International Criminal Court. The ICC has recognized the crime of aggression as an international crime since the relevant provisions became effective in 2018. But of course, the ICC can act only with the approval of the UN Security Council, over which the Russian Federation has a veto, or alternatively against the nationals of a state that has agreed to be subject to the court's jurisdiction over aggression. And as of today, only 43 of the International Criminal Court's 123 states parties have accepted that jurisdiction over aggression. Neither Russia nor Ukraine is a party to the IC. As you know, Ukraine has twice declared that it accepts the jurisdiction of the court for crimes committed within its territory. But Russia's status as a non-state party bars the ICC from addressing aggression in this conflict. Nevertheless, the Rome Statute definition reflects the most considered and wide-ranging thinking of academic and state experts and is relevant to any consideration of any mechanism that might prosecute aggression. Article 8 bis 2 of the Rome Statute describes a number of acts which, regardless of a declaration of war, may qualify as an act of aggression. And these include the invasion or attack by the armed forces of a state of the territory of another state, the bombardment by the armed forces of a state against the territory of another state, the blockade of the ports or coasts, an attack by the armed forces on the land, sea, or air forces or air fleets of another state. Those are all examples of acts of aggression. For the purposes of the Rome Statute definition, the crime of aggression means the planning, preparation, initiation, or execution of one or more of those acts of aggression by a person in a position who effectively can exercise control over or direct the political or military action of a state. Now, what constitutes planning or preparation of an act of aggression? Planning could include participating in high-level meetings during which plans for the acts of aggression are formulated, or enacting legislation or decrees concerning the aggressive plans. Preparation could involve speeches by relevant officials purporting to justify the invasion in the eyes of the law. This could include President Putin's speech on February 24 of this year, in which he sought to explain the invasion as an act of self-defense. Or it might include a speech, for example, by Foreign Minister Lavrov in April of last year, claiming that the United States was engaged especially assertively in military activity in Ukraine. Now, for the crime of aggression, a central challenge is deciding who are the persons in position effectively to exercise control over or to direct the military or political action of a state. In the context of aggression against Ukraine, there are a number of such persons, but in our model indictment, which you have, we have selected 8 persons who we believe clearly qualify. President Putin, who's the head of state and commander-in-chief of the armed forces, Sergei Lavrov as the foreign minister, Sergei Shoigu, the defense minister, Valery Gerasimov, the chief of the general staff of the Russian armed forces and the first deputy minister of defense, Nikolai Patrushev, secretary of the Russian Security Council, Sergei Narishkin, director of the Russian Foreign Intelligence Service, Alentina Matvienko, speaker of the Federation Council, and Sergei Beseda, who heads the Foreign Intelligence and Espionage branch of the FSB. The model indictment sets forth one or more acts committed by each of these proposed accused, which contributed to the crime of aggression. Now, once it is established, first, that acts of aggression were planned, prepared, initiated, or executed, and that they were done by one or more persons who are in a position effectively to exercise control over or direct the action of a state, then the final component of the crime of aggression is that the acts of aggression, by their character, gravity, and scale, must constitute a manifest violation of the Charter of the United Nations. Now, the criterion of manifest violation applies to uses of force which indisputably violate the prohibition on the threat of use or use of force that is enshrined in Article 2.4 of the UN Charter. In this case, Russia's acts of aggression are manifest violations of the Charter by virtue both of their illegal character and their gravity and scale. As to their illegal character, Russia has sought to justify the use of armed force in Ukraine as an act of self-defense. But Russia could not legally resort to individual self-defense, as Ukraine had not committed an armed attack against Russia and did not pose an imminent threat to Russia, and Russia's military action was neither necessary nor proportionate. And Russia could not legally resort to collective self-defense to protect the Donetsk People's Republic or the Luhansk People's Republic, as these entities are not states under international law, which can give rise to collective self-defense or request forcible assistance from Russia. So as to their gravity and scale, the initial February assault on Ukraine's territory was widespread and far-reaching in terms of geography and human and physical cost. And these costs have, of course, only mounted in the more than 7 months since, including, as those of us in this room have witnessed as recently as yesterday and today. If I have a couple more minutes, I can just turn very briefly to begin the question of where those who are responsible for aggression could be prosecuted and tried. Now, there are currently 3 streams of judicial activity with respect to crimes underway in Ukraine. Taken together, they make clear the need for some new judicial mechanism to address aggression and other crimes. First, the Prosecutor General's Office of Ukraine, of course, has said that it has opened investigations into more than 30,000 crimes of what it calls aggression and war crimes. It is, of course, laudable that national prosecutors are doing what they can. However, it is no surprise that with the tidal wave of crimes committed since February 24, let alone what happened in the 8 years before, the Ukrainian judiciary is overwhelmed, as a number of Ukrainian criminal justice officials have themselves acknowledged any justice system in the world would be. There is assistance that's being provided to national prosecutors by a number of countries. But even with that assistance, it's unlikely that Ukrainian prosecutors will be able to develop many cases against more than low-level direct perpetrators, or that this approach is going to develop a domestic system over time that is prepared to handle war crimes cases for years to come. A second stream of activity is led by the International Criminal Court based in The Hague, which of course is investigating any possible war crimes or crimes against humanity committed on any part of the territory of Ukraine, including Crimea and the Donbass, from the 21st of November 2013 onwards to the present. However, the ICC is a global court. It must stretch its limited resources across many, many jurisdictions and situations around the world, and proving cases against the senior leaders responsible for war crimes and crimes against humanity is very, very hard to do. The ICC prosecutor can be expected to bring charges against only a handful of suspects. And moreover, as we've discussed, the ICC lacks jurisdiction over the crime of aggression as it pertains to this conflict. Beyond the ICC, there are more than a dozen European and other national jurisdictions that have opened criminal investigations at the national level into international crimes in Ukraine, many of them under the principle of universal jurisdiction. Such proceedings have been important in the past in other contexts, while some of these states, including Ukraine, of course, have jurisdiction over the crime of aggression. Under most interpretations of customary international law, top Russian officials will enjoy immunity from prosecution before any national court. So in sum, notwithstanding the varied investigations underway, there are significant gaps in accountability for crimes in Ukraine, three of which are paramount. First of all, there must be justice for the crime of aggression, and any tribunal that is created must be able to overcome the claim of immunity for the most senior officials. Secondly, even beyond the crime of aggression, there must be a way to hold accountable the most responsible perpetrators of war crimes and crimes against humanity beyond the small number of suspects that the ICC prosecutor is likely to charge. And finally, the international community must begin to take measures now to strengthen Ukraine's judicial system so that it is capable of handling war crimes long after international attention has turned elsewhere. So with that, I think I'd like to conclude, and I very much look forward to questions, comments of my colleagues, and further discussion among you in the room. Thank you.
We're faced with a dilemma. Could mass media representatives be held accountable? I'm talking about those state TV channels that formed this idea in the heads of the Russian that the aggression was necessary, and they convinced many people that aggression made sense. Maybe there's international expertise, something similar. So could they be prosecuted with this crime? If we look at the definition of aggression, then the president of Belarus, should he be seen as an accomplice in this crime? So I read this model indictment, and I think one name is missing there.
So thanks so much. And I mean, as your question suggests, there's a lot to be discussed and considered in thinking about these issues. Thankfully, we also have, and we'll hear from David, who is in his own right a leading expert on the crime of aggression and international law more generally. So I'd welcome his thoughts later on when he speaks. But from my part, in terms of the responsibility of the mass media, of course, we've seen precedents in international justice where persons who control the mass media have been held responsible for contributing to serious crimes, including of genocide. With respect to the crime of aggression, particularly, of course, one must recall that a key element is that the crime, at least as defined in the Rome Statute, is that it must be committed by one or more persons in a position who effectively to exercise control over or direct the political or military action of a state. Someone who has effectively that power. So in addressing the question of whether someone from the media would be able to be held to account, I think one's going to have to really ask the question in light of that pretty restrictive test of category of individuals. In terms of the question of accomplice crime, therein, again, I think the question is what is the state? Direct the political or military action of a state that has committed the crime of aggression. Can there be accomplice liability with respect to the crime of aggression? I think that is a question that there has been quite a difference of opinion with respect to. I think in addition to the question, and I'd love to hear David on this, in addition to legally what is possible, I guess I also think it's important to think about strategically what is in the interest of a tribunal that is duly constituted to charge which individuals and how broad a net to cast in trying to achieve both a comprehensive reflection of those who hold responsibility for the crime and nonetheless undertake actions which will be sustainable and hold fast upon any judicial review and in a court of appeal, which any duly constituted tribunal would have to have. So I think these are challenging questions that merit further discussion. But I think the fundamental point is that the test is going to be pretty rigorous in terms of a narrow range of individuals who could be held accountable. At least that's my sense of things.
I can see that there's a comment from David in the chat. He believes that the president of Belarus is a co-perpetrator of the crime of aggression. I think we will not be focusing on additional co-perpetrators now, and we will give the floor to David for his 10-minute presentation a bit later. And now I would like to give the floor to Anton Korynevych, who is actively involved in talks with international partners of Ukraine to find an accountability mechanism for crime of aggression, because developing of this international mechanism is exactly what could be the solution to the challenge that we are faced with as citizens of Ukraine and probably international community as well. So there's very specific suggestion from Ukrainian president, Ukrainian government, which is being discussed at various platforms and is on the tables of the leaders of many countries. And I would like to ask Anton to present this idea to us, its advantages and whether it addresses the issues that we're faced with, and where we could use certain elements of this document.
Thank you so much, Mr. Roman. Hello, dear colleagues. This is the greatest pleasure to be here with you today. And I've heard, of course, a lot and read a lot about Just Talk. This is my first time here, and I believe these are very important legal discussions, which is why we have to get concentrated on the justice, and of course the subject would be international law, and in particular the aggression crime and responsibility, liability for it. Whenever we speak about international law, the notion of aggression is there in two areas, as actually within the framework of the law and within the framework of the crime committed by the leadership of the country, as Mr. Jim has mentioned today. And we speak about Roman Statute, Article 8. So, speaking about holding the Russian Federation liable for the act of aggression, we have some objective obstacles there, because the only international organization, the key authority, actually, which can establish the aggression fact legally, after which there may be some legal conclusions, would be the Security Council of UN. Today, it's not possible for the Security Council of UN to acknowledge this aggression. So, the General Assembly, as well as various EU authorities, the Council of Europe authorities, may be recognizing this crime, but this will have no consequences. So, we need to be based on the second incarnation, mentioned the crime of aggression committed by leadership of a country. And here we shall speak about the fact that today, not just us as Ukraine, but also international community find ourselves in this spot. And if today there would be no liability for the aggression crime against Ukraine, which is obvious for everybody, then this crime will be stillbirth. And if nobody is held liable for the aggression crime against our country, then all these 43 ratifications, that would be just paper tiger, because the international community will show its impotence to do anything in this situation of overcomplicated aggression, starting from the greatest aggression started from 1945. Well, this would be a failure. And this war is not actually a military crime. This is not a crime against humanity. When they say get concentrated on the available mechanisms which can be applicable for crimes against humanity, war crimes, no, it won't work. We have so many violations on the side of the leadership of the Russian Federation, which are neither war crimes nor crimes against humanity. That's fact number one. Fact number two, from the viewpoint of law, and you mentioned it, it's very difficult to actually establish the allies of this very crime. For example, who committed the crime in Bucha requires very serious work, and actually it may not result in the outcome we would like to see. And there are reservations that these crimes on these cases on crimes against humanity will result in certain indictments. Again, this middle link, not even top brass of the Russian armed forces. Of course, it shall be done, but Russia and its leadership shall be held liable full-fledgedly. Since 2014, the government of Ukraine is so active in all the international courts to bring Russian Federation to liability. We're everywhere, in every jurisdiction where we just can be. International Court, European Court for Human Rights, Marine International Tribunal, plenty of other tribunals against the Russian Federation as a state. But what we see, there are these accountability gaps which cannot be filled by the elements because they are not there today. And the Ministers' Committee of the Council of Europe, as of the 15th of September, established a comprehensive accountability system. And namely, this comprehensive accountability system stipulates for liability for the aggression crime. We cannot fail here. And, if just two majors and two privates are held liable, this is not liability for whatever was done to our country since 2014. Appropriately, the question is how to help this state and these people liable, and why the government of Ukraine offers creating the International Tribunal on this crime. As Jim mentioned, we shall not reiterate that much, ICC cannot be working with the aggression crimes. It won't have the jurisdiction, full stop. That's a fact. And the national courts of Ukraine, Mr. Belousov is here, can work on the aggression crime, but not as regards the top leadership of the Russian Federation. Head of the state, Minister of Internal Affairs, no, because they have functional immunity, and which is why not a single national jurisdiction can work here, not just Ukrainian courts. So if we don't create something new, then President Putin and representatives of his team will avoid liability. They won't be held liable at all. We believe that as of today, the best option, the best legitimate option would be creation of a special international tribunal, namely as regards aggression crime, just this one crime. Why namely this one crime? Because all the other crimes can be covered by other courts, national courts and ICC too. And if we offer international tribunal which deals with crimes against humanity, war crimes, then they would mention that we are creating an alternative to ICC, and would be right, which is why we want to have this compact tribunal for just one crime, which is not an alternative to International Criminal Court, but it will be kind of a very good, well-needed addition to hold liable for aggression crimes. So we operate in this tribunal based on the rules which are there in Roman Tribunal, Roman Statute, and I really like this statute. I'm always saying it, not just here. And you know, ICC is a huge achievement with its statute, and I believe a lot of rules shall and may be used as the basis for this special tribunal. The government of Ukraine, together with our international partners, together with our colleagues from the academia circles, we've been working on this starting from the end of February, and we already have certain level, good level of political support. Yes, we don't speak about politics today, but this Thursday we expect another resolution of the Parliamentary Assembly of the Council of Europe, which will speed up our movement towards the creation of this special tribunal, because everybody understands that, namely, the special tribunal can help us answering the question how to hold this country liable for that crime and for initiating the war, which resulted in all these crimes, because the crime of aggression is the mother crime, which gave birth to all the other crimes. And now we find ourselves in this very intersection when we have to decide what would be the model, the best model for creation of the International Tribunal. Will there be multilateral agreement between states, as they had in Nuremberg, in order to create a special tribunal, or is it going to be an agreement of Ukraine with UN, understanding that we have to use the way through the Assembly General, not the Security Council, and it's going to be a proper resolution on this tribunal. Everybody has to understand all the risks. So maybe it shall be a tribunal based on the agreement with the European Union or the Council of Europe, meaning European Regional Organization. We're having a look at all these options, and in order to make our selection, we need a feedback from our international partners, because we can't select an option and later on there will be a response that that's not the best option. Speaking about our international partners, there are such partners who are ready to support any option offered by Ukraine. There are such partners who are just in the listening mode, and there are those who are saying, we need some umbrella from some organizations. Let us think about multilateral agreement. We are working on all these issues, and we see, and I believe that we've already shaped up an important thesis here, or statement here. The accountability for the crime of aggression against Ukraine must be secured, right? So this is crystal clear, and I believe this is a very important first element. And then we will be moving towards the second element, in what way to do that. And when we analyze in what way, we see that apart from creating a new mechanism, this liability won't be possible at all today. We've prepared the draft agreement and draft statute of the Special Tribunal. We provided it to our international partners, and it's been shaped up in such a way, like in this options format, either A or B or C, right? We select one option, we get rid of all the redundant, and we still have this body. And the key thing for this mechanism, for this tribunal, it shall be as international as possible. It shall include as many international judiciary bodies elements as possible, not just because we want so, but because it's important in order to overcome this elephant in the room. The issue of immunity is important. Not a single national court can arrest Putin, but international body, which would be based legitimately on the international law, can't do that. So we believe that this tribunal is essential. We believe that's the best or the only option to hold this country or its leadership liable for the aggression against Ukraine. And we cannot be speaking just about war crimes and crimes against humanity here, possible genocide crime, because then we may not reach the leadership. I believe it would be a failure for us, right? Because they are the source of this evil. Putin's decision is evil. His decision in 2014, in 2022, which is why we need to do this. Speaking about the model indictment, we, in our work, actually referencing this document, and there is another important American document, but this work is very important and valuable because this document shows that several lawyers who are united by one goal can get together and create a very high-quality indictment, which can become the foundation for the arrest warrant of the leadership of the Russian Federation, which means when we create the special tribunal, the prosecutor's office can, in few months, when they desire so, can actually create all the necessary indictments and issue arrest warrants for the leadership of the Russian Federation. So I would like to reiterate, we are using this argument. Our international partners know about it, representatives of all the legal services, appropriate ministries of justice, of foreign affairs. And once again, this is a good argument to show it's doable. And a key thing, we, us as lawyers, we can find 150,000 arguments why we shall not start it even, why shall we not be doing it. But we need to understand there are some issues when we have to tell ourselves all legal challenges, all legal obstacles are overcomable. We need to overcome them in order to ensure justice and in order to have a proper, a full-fledged liability system in place. What we ask of our international partners would be to find a political will for this tribunal to take place, to happen, to be created. If there is political will on the side of the political leadership of our partners, well, all the other things would be just small things. We can move forward when united. Thank you, Mr. Anton, for this very vivid presentation. You persuaded me, but I have a question. I suspect that it won't be that smooth, and you still have some problems with persuading other stakeholders. Maybe now or later on, when you have an opportunity to tell, what are the legal arguments you hear against your idea? I mean, just legal arguments. I understand there would be a lot of criticism, but something really legal, really to the point. And I understand the aggression crime. Well, I suspect that a lot of people will think how to separate the crime of aggression and what we call humanitarian intervention. In plenty of countries, they violate somebody's borders, meaning borders of other countries, and won't it be an obstacle for you? Thank you so much, Arya Mora, Ukrainian Legal Advisory Group. I have two short questions. The first one, speaking about accountability gap you've mentioned, well, how do we overcome this gap in terms of aggression crime? If we're not speaking about the war crime or crime against humanity, so how do we deal with this gap in terms of this crime? And second of all, you say that the mechanism which will have the mandate, which would include war crimes, crimes against humanity, would mean competition or alternative to ICC. Yes, that's really so. With due account that there are some precedents when it was already done previously. Or can we avoid this obstacle somehow for it not to be viewed as an alternative? Vladimir Yavorsky, I have one short question. I believe that the key discussion here shall be around how to legally create this tribunal, because there are plenty of issues for it to be legitimate. If we are selecting a way of international agreement, then according to this agreement, countries are deciding on the destiny of another country which is not party to this agreement. And this will create a dangerous precedent, because Russia will start creating their own tribunal with the countries which are friends to them in order to actually make Ukraine liable for certain crimes which it commits in their eyes, and it can turn into a chaos, right? And also, they may also identify this as not crimes but humanitarian interventions. So I don't see any clear legal opportunities to do so without a reform of the Security Council. Thank you so much. And there at the back, another question or remark? A question to Mr. Anton. Mr. Anton, what do you think? Maybe, well, you've offered all these models of specialized tribunal and bringing the leadership of the Russian Federation to liberty. Maybe, if Russia is recognized as a state sponsor of terrorism, maybe it will make our lives easier in terms of creating the International Tribunal. What do you think? Thank you so much for your question. Of course, all these questions are very good ones. Speaking about Bushchenko, Mr. Judge, yes, it's not that smooth, and it's clear, because we speak about aggression crime, and the crime of aggression is always overcomplicated. Yes, there are certain states who've got certain history of their behavior. Nevertheless, at the same time, what legal questions are asked by our partners? We always hear the question, is actually the accountability gap too big? Why don't you want to operate within just crime against humanity and war crime? Well, the best thing would be to answer that we can't blame a person who sits in the Kremlin of the war crime. That's not that simple, right? Which is why that's important. The second argument, almost everybody, they say, but we've got ICC, resort to International Criminal Court. Let them do their job. And we are answering that we love ICC, we respect ICC, and Verkhovna Rada of Ukraine, the Supreme Council of Ukraine, passed a range of pieces of legislation where they stipulate for cooperation with ICC, and we are speaking about opening of a field office in Ukraine. We are closely cooperating with ICC, but no, ICC cannot cover this issue. There's this political question, although you asked me to get concentrated on legal questions, but there are so many political questions. They say, how are you going to agree with Russia later on anything? Well, I think the President of Ukraine answered this question better than I could answer it, and this is not our question at all. But yeah, we hear this question quite often. Later on, you have to negotiate peace. And speaking about humanitarian intervention, yes, very good question. But I believe in this case, we have one peculiarity or difference. There are so many resolutions of international organizations, including our General Assembly of UN, which recognize the aggression of the Russian Federation against Ukraine. We have this background, which will be the basis, which will show that this is not, right to protect, responsibility to protect, humanitarian intervention. And speaking about other questions from Mr. Aryan from Ukrainian Legal Advisory Group, well, we are saying that, yes, Putin shall be brought to liability, not just Putin. Putin, Lavrov, Shoigu, Gerasimov, Mishustin, we shall try holding them liable for war crimes and crimes against humanity, but their liability for the aggression crime is so obvious. Like, why forgetting about it? If there's this international aggression crime, like, why shall we turn a blind eye towards it? And this is what I have in my hands, right? This is already the aggression crime. This is a very good proof. And speaking about the mechanism which may cover everything, I mean, when we speak about international authority, and we want this tribunal to be an international one, I'm not speaking about hybrid tribunal mechanism strengthening the national system. I'm telling that creation of a parallel international tribunal, right? Like Uganda or Yugoslavia international tribunal. Well, our partners would not allow us having something like this. And I'm not speaking about domestic jurisdiction or hybrid options. But the question of Mr. Volodymyr, well, I'm not entitled to discuss the issue of the reform of the Security Council, though I have a lot to say as regards this. So from the viewpoint of international law, the most ideal option would be really acting through UN, United Nations, right? This is not such an obvious option for us, like to go to UN, get a resolution which would have a phrase of UN signing an agreement with Ukraine on creation of such a tribunal. Well, this is an ideal option, but still, we have to be very careful. And I agree with you completely that, of course, the Security Council would be the best option, would be in ideal world. And speaking about multilateral agreement, I believe that if we keep this statute or agreement formulated properly, and we allow the tribunal to act on behalf of the international community, if this statute would ensure some endorsement, right, for it to be supported politically by international organizations, key regional organizations, then the Russian tribunal, together with Syria and Nauru, won't be a serious challenge for us, because we will have Ukrainian tribunal with the support of so many reputable international organizations and countries. I believe this is already an argument. And the last question about a terrorist country or country sponsor of terrorism, well, this may not be directly related to what we discuss here, but that's important. Have a look. We are saying that we are creating a portfolio of all these things. If we have recognition of Russia as the country sponsor of terrorism by the parliaments of the countries of the world, of course, it will add to the understanding of key decision makers that the tribunal is also necessary, because it all is done in the context of the aggression against us, which is why I believe that, well, these issues are not legally related, but they are still interlinked. we were mentioning the Rome Statute of laws and all the annexes and ICC. And today, with us, we have a very important partner who actually urges Ukraine to ratify the statutes and who works a lot on liability for international crimes. Mr. Kattin, and he is a well-known expert in these issues. He's the head of an organization, Parliament for Global Actions, and he kindly agreed to participate in today's conversation. And I know that David was analyzing in parallel other ways of ensuring the liability for crime of aggression. And I would like to give the floor to him now and to hear actually his opinion, his thoughts. What kind of options are there in front of us, and whether creation of this complex tribunal is the only option which is out there? And actually, please mention what would be your pieces of advice here, and I give the floor to David here.
Thank you, Roman, and really I'm really impressed by what you have been able to put together, notwithstanding what's going on. And if I can say something from another continent here, is that our hearts and minds and full solidarity are with the victims who died yesterday, today, the day before yesterday, and each and every day of this senseless war of aggression, which was launched without the understanding that it will never succeed. I had the privilege to work with members of the Ukrainian Rada in these last 9 years. I had the privilege to work with you, Roman, and your colleagues from civil society. I've been in Kiev 8 times, and not a single time I could see weaknesses. Of course, we all have weaknesses, but weaknesses to the level that would justify, even in the, for any incredible imagination, to think that anyone could invade and occupy and destroy a free country as Ukraine is. So I really, the more I think about the ongoing war of aggression, the more I don't understand. It's totally illogical. It's totally senseless. This brings us to the importance of the crime of aggression. Because from a legal point of view, philosophy of law, not political, legal point of view, it is absolutely unacceptable that if I kill one person in the streets of New York under my house, there are 90% of chances I get caught, 80% chances I get convicted. Am I right? And if instead, as a head of state, I use the war machinery that I have at my disposal and I launch an aggressive war, there is 0% possibility that I get convicted. It's absolutely unacceptable. Now, why are we in this situation? Because after the euphoria that brought about the defeat of the Nazi fascist regimes and the Japanese Empire in 1945. And let's remember, everything started with the Moscow Declaration of 1943, which did not require Nazi Germany, fascist Italy, or imperialistic Japan to agree on the Moscow Declaration. The Moscow Declaration imposed individual criminal responsibility on the persons responsible for the World War II aggressive war. We didn't need the consent of the Nazis at that time. We don't need the consent of Russia today. Therefore, the competent body to decide on the creation of a special tribunal is the United Nations General Assembly, where you apply the general principle of law of equality of states, one state, one vote. Do we have more than 90 votes at the General Assembly, 95 votes or 100 votes as they are required? I think we have them. So in terms of procedural requirements, I have no doubt that a special tribunal can be created, and this loophole in the international legal system can be filled. So I would urge Ambassador Anton and the government of Ukraine to present a resolution tomorrow, not today maybe, but tomorrow. I have no doubt that there are more than 100 votes. What is the real problem, however? Is it fair and just under a theory of law, a general theory of law, that we deal with the aggressor as we need to deal today, and we don't have a mechanism tomorrow for the next aggressor to be dealt with in the same and equal manner? That's unfair and unjust. That doesn't mean that we would not need to support today a special tribunal. But what we need to do is to make sure that, unlike what happened in Nuremberg, we now have a system that is permanent and universal. Universal doesn't mean that everybody must accept it. It means that it should apply to everyone equally. Because if we ask the mafia in Sicily to legitimize the trials of their leaders, they will say no, but we don't need their consent, correct? So I invite you, I heard a question before about legitimacy. Forget legitimacy, we need legality. Forget legitimacy, we are not interested. We are only interested in legality. Now, and this is the only point where I disagree with my learned colleagues in the room today. In reality, if there was a majority of states willing to amend the Rome Statute and realign the jurisdiction of Article 8 bis, crime of aggression, to the jurisdiction of Article 6, 7, and 8, namely genocide, crimes against humanity, and war crimes, if there was a majority willing to first present and then vote, and a two-thirds majority to effect that amendment, we could have, within the time frame of 3-4 months, an active jurisdiction of the ICC on the crime of aggression. The problem that we have is that the same states who are probably telling to the government of Ukraine not to present the resolution that it could present tomorrow are the same who are not ready to present and vote on an amendment to the Rome Statute to unlock the jurisdiction of the ICC. Because they still believe, and I am observing here as a public international lawyer the practice of states, and states are the lawmakers in international law, unfortunately. That's the reality that we have to deal with. Sovereign states are the lawmakers. And unfortunately, many states, several states, do not believe that exercising jurisdiction on the crime of aggression can help the resolution of the armed conflict. And of course, I'm using this terminology to be lenient and not too critical on them, because it's a war of aggression. It's not only an armed conflict. We have many, many armed conflicts and very few wars of aggression. Now, so the same problems that we have for the creation of a special tribunal exist for the amendment to the Rome Statute. The position that I take is that you need both, because without a commitment to amend the Rome Statute and ensure that crime of aggression will be a justiciable crime as genocide, crimes against humanity, and war crimes for any other aggressions of tomorrow, will not galvanize enough state votes to make it sustainable for the special tribunal resolution to be universally accepted. Maybe today we have 100 votes, but if we would have a commitment to amend the Rome Statute, we would have maybe 140 or 150 votes. What is the problem? And I need to be very clear here. Just read the latest statement of the EU-Ukraine Association Council. On one side, Ukraine asks the European Union, as it is asking all the UN member states, of course, to endorse the proposal to create a special tribunal. On the other side, the EU is asking Ukraine to somehow speed up the process to join and ratify the Rome Statute of the ICC. So this major contradiction in the state practice of Ukraine as a state is essentially weakening the demand of this special tribunal, because it's not clear why this development did not take place as of today. I think that international law is based on the consent of states. Now, if the consent is given ad hoc to a treaty-based system, as Ukraine did in 2014 and 15, accepting the jurisdiction of the court, that, of course, has legal consequence insofar as the article concerned is to be understood, Article 12.3 of the Rome Statute. But the qualitative implications of the consent to be bound for good to the Rome Statute of the ICC would be assessed in a very different way by the 123 ICC state parties, and especially the 27 EU member states, which are the closest economic, social, and cultural allies of Ukraine, insofar as Ukraine is a state that is entering the doors of European integration and enlargement, European Union enlargement. So I think it is all these processes are interconnected, and they are all about treaties. The EU, when you enter the EU, you are bound by the EU treaties. When you enter the Rome Statute when you enter the ICC, you are bound by the Rome Statute. As a member state of the UN, Ukraine is bound by the United Nations Charter. And yesterday, I was shocked to notice that in the 6th Committee of the United Nations General Assembly, the Russian Federation, the Islamic Republic of Iran, Belarus, the North Korea, and a few others, I believe Syria, they set up a group of Friends of the UN Charter. Can you believe it? They self-named themselves the group of the Friends of the UN Charter. I cannot believe it. They are trying to block a decision of the General Assembly to create an ad hoc committee for the drafting and the adoption of a Crimes Against Humanity Convention. So, I think what we need to do is to be the real friends, we, the rest of the international community, of the United Nations Charter, and ensure that every time that the Security Council fails to apply the Charter and violates its own Charter by not being able to restore international peace and security, the United Nations General Assembly intervenes with decisions that, albeit not being legally binding, they become so on the basis of the consent of the territorial state that will enter into an executive agreement. And we have a precedent, the agreement between Lebanon and the UNGA for the creation of the Special Tribunal. And we also have a statute, the one that was done with Sierra Leone, but at that time the agreement was between Sierra Leone and the UN after a Security Council resolution that we will not have in this case. So we have plenty of precedents. The Yale Club recently hosted a meeting with the top scholars that pronounce themselves in favor of this. I invite you to read a number of posts on the Just Security web from the top scholars like Jennifer Traham, Hannah Hathaway, supported by others from Astrid Reisinger-Corazzini from Vienna, many others, not only from the US, uniting their voice, and a lot of states attended those events. I was an observer, and I can tell you, there is no doubt this can be done very quickly and effectively. And as Jim Goldstone told you, the indictment will be ready to be served. So I think what we need to move forward is to really overcome the contradictions, if I am allowed to do so. And you, as the most important practitioners in the wonderful country of Ukraine, you can have a suggestion to be given to your president to deblock the ratification process, if possible. I'm sure the Rada will vote unanimously for it. And at the same time, as a state party, you will also be able, in parallel to the proposal to create the special tribunal for now, to also propose the amendments to the Rome Statute that you can have scholars like Professor Klaus Kress and others to validate our line, are now available. We have not published them, not to say you can just do this, because it's not our role as an NGO to replace governments. We are humble and we know that only states can change the law in international lawmaking. And this is a task that, in our view, Ukraine or other states that are parties to the Rome Statute can do authoritatively. Now, a final point on the actual scope of the crime of aggression that Jim called me to comment on. In Nuremberg, we had a very primitive law. And essentially, anyone who adhered voluntarily to the Nazi project could have been indicted for crimes against the peace, the crime of aggression, as not defined at that time. It was because the definition of Nuremberg is the crime of aggression is the crime of aggression. I mean, the crimes against the peace are the crimes that violates the integrity, blah, blah, blah. But it doesn't really give you the specificity that we have today, which meets the modern requirements of the principle of legality and excludes the legality issue on the humanitarian intervention. Because why humanitarian intervention is, according to a majority view, illegal under international law, it does not meet the high-level threshold of gravity of Article 8 bis defining the crime of aggression. So Article 8 bis of the Rome Statute allow us to say humanitarian intervention, yes, illegal, but not aggression, not a jus cogens violations. So no problem with humanitarian intervention. The problem is that some states committed wars of aggressions. Not only Russia did so, and we have at least 3 examples. One of them was when the Soviet Union invaded Afghanistan in 1980, or when Iraq invaded Kuwait. So, but they're very rare, the wars of aggression. They're very rare. So we have to fill that gap. And I think today we have a definition that allows us to really focus, as Jim explained so well, on the top level of the chain of command. And the test is who is in charge effectively to command and control. So Mr. Lukashenko is certainly not in charge of the Russian army, but is in charge of the access to the Belarusian territory, because he's the head of state. So by allowing Belarus to be a transit state and by allowing the territory of Belarus to be used for the bombings that took place on the 24, 25, 26 of February and following days, he is a co-perpetrator because he is enabling the main perpetrator to commit the crime. Of course, others might be voluntarily adhering to the idea that Ukraine should become part of Russia and things like that, crazy things like that. But they are not meeting the test of command and control. So I invite you not to make the mistake, not any ideologue, not any volunteer, not any member of the Wagner group can be qualified as author of the crime of aggression. Only those who meet the threshold of being effectively in command and control of the military structure that is invading Ukraine or another sovereign country. So I think that helps us to allow generals, colonels, and others to say, well, I didn't want this to happen. Okay, perfect. Not guilty, not indictable, but please testify that you were given the order. So that's also what we need to do to end this war in the sense of reconstituting the territorial integrity and the full political independence of Ukraine. We need to create incentives for those who are not in command and control to mobilize, defect, and isolate those who are in command and control. So the crime of aggression, and I terminate my presentation on this key point, which is both legal and also political, the crime of aggression, if used, can help to create the condition for a sustainable and durable peace, to the contrary of the opinion of the presidents of certain big countries who wants to save the face to Mr. Putin and blah, 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 I disagree with those positions. When you name a perpetrator for the crime he committed, even though we don't have an international police that can arrest him immediately, you make clarity. You bring clarity to the negotiating table. And those who need to make peace, they know who can sustain the peace and who cannot sustain the peace. And it's in the interest of those who have been victimized by the crime of aggression to make the peace as durable and sustainable. So, in other words, by incriminating Mr. Putin and the other top leaders who are in command and control, we are giving the opportunity to thousands of members of the nomenclatura in Moscow and elsewhere to say, hey, enough is enough. Time to restore the proper exercise of sovereignty under the Constitution. And by the way, who is the victim of the crime of aggression? Each and every person whose life has been affected by the aggressive war. Each and every Ukrainian, each and every individual victim, each and every Ukrainian soldier who has been killed, unfortunately, is not protected, or she is not protected by international humanitarian law, because it's legitimate, it's lawful to kill him by the Russian forces. It's not a war crime. Whether we like it or not, international humanitarian law does not protect those who are in combat. Okay, so the Ukrainian victims of the war are not victims of war crimes or crimes against humanity or genocide, but they are victims of the crime of aggression. And also, those Russian soldiers who are dying every day, killed by the Ukrainian resistance, lawfully, are the victim of a crime, the crime of aggression perpetrated against them by the leadership of the Russian Federation. So the crime of aggression is absolutely necessary because it indicates who is guilty and who is not guilty. And by individualizing the guilt, we can create the condition for real peace in Ukraine and in the world. So, I finish this presentation by saying that Ukraine can be as a state, can be the game changer, because not only for the sake of Ukraine and for the sake of the victims that are suffering so much from this illegal war, but also for the sake of humanity and the entire planet, you can really create the precedent that can change international law and bring us back to the dream that we had in 1945 after World War II, finally. So you have a lot on your shoulder, but I think we will all win with this. And because this is a battle that needs to be won alongside, of course, the liberation of all the territories unlawfully occupied. Thank you.
I'm very grateful to David for returning to address the questions that we already heard from the audience. I would like to give the floor to Eric Witte from the Open Society Justice Initiatives, global programs. Eric worked with various accountability mechanisms, accountability for international crimes, ICC in particular, and Special Sierra Leone Tribunal. And I have a question to Special Court for Sierra Leone. I have a question to Eric. What would be a way to overcome immunity? Would other mechanisms be able to help deal with that? Because we all know whom this model indictment is with regards to, but these persons, they are protected by sovereign immunity, what Anton Korynevych was talking about. So what about that? What are the mechanisms to help us in this respect? There are pros and cons based on what we have now. Eric, over to you.
Thank you very much, Roman, and thank you, everyone. It's really a pleasure and an honor to be here. We've just had, in these past couple of days, a very small taste of what you've been going through since February, and indeed since over the last 9 years. So, I mean, there's been a lot of powerful arguments put forward today for why it's so important to prosecute the crime of aggression. And indeed, there are different models, but immunities are a major factor. And it's clear that domestic courts would not be the right venue to prosecute the crime of aggression against leadership figures, even though you do have a crime of aggression in Ukrainian law, because it's widely recognized that immunities apply in domestic courts. So what kind of a court is needed to overcome these immunities? And it's clear that the more international in nature the court is, the clearer the case is that immunities do not apply. But that said, I mean, we've spoken at length today about the gap in accountability for the crime of aggression. But I do want to go back to what Jim was talking about, the other two gaps. You're faced already with tens of thousands of cases. Any justice system in the world would be completely overwhelmed by what you're facing. And this is not a question just for you in the months and next couple of years to come. This is a question for the next generation of legal practitioners as well. I think Ukraine will be investigating and prosecuting these crimes for the next 5, 10, 20, maybe 30 years, looking at the experiences of other countries that have gone through mass numbers of atrocities. So I think it's worth stepping back and thinking about what those years look like and what the capacity needs are, not just today, as you're still under fire, facing urgent demands, urgent needs for accountability, but what does it take to achieve accountability on a scale that is more commensurate with the popular demand that is very much justified for the level of war crimes and crimes against humanity you're facing, given the fact that the ICC can only take a handful of cases, as Jim mentioned. So I don't think it's enough to say, well, the ICC is doing it. Well, and you're leading the War Crimes Department, and there's very active mobilization of legal and resources, juridical resources in this country to deal with this tidal wave of criminality. But as I said, I mean, it's not normal to think that any system in the world, no matter how developed, would be able to handle the sheer number of cases and expertise along the entire judicial chain does not develop overnight. And we're not just talking about investigations and prosecutions. We're talking about witness protection. We're talking about outreach to victims. We're talking about provision of psychosocial support to victims. We're talking about defense, because the legitimacy of these proceedings is hugely important. We are going to see, indeed, efforts by Russia to set up sham trials of Ukrainian prisoners of war. And it's vitally important that there be a bright, clear line between the standards of justice in Ukraine and what we can expect from Russia. There should be no doubt that Ukraine is taking every measure to adhere to international standards. So I would suggest that it's worth asking the question, as we seek to fill this gap on the crime of aggression, what else can be done now to answer that need in a way that it does address the immediate term gaps for capacity and the longer term need to make sure that Ukraine and Ukraine alone has that capacity in the long term, because international attention will turn elsewhere eventually. And I think there are models to do that. Hybrid justice models, and there are two main sort of models that looks like, more like in Bosnia and Herzegovina at the state court, where international elements were integrated into national offices for a temporary period of time, and then they left over time, and were quite effective in helping to build domestic capacity. And today the State Court of Bosnia and Herzegovina is entirely Bosnian. So there's that kind of model that does take legislative, a lot of legislation. It takes constitutional change to allow international judges to participate, among other things. And that could be a very difficult path due to those needs. There's the other model of the Special Court for Sierra Leone, where I worked for a couple of years. And that sits outside of the normal justice system. It could be established as a hybrid national international court inside the territory of Ukraine or outside, or with some flexibility depending on security circumstances. But again, where Ukrainians and international experts could work side by side, outside of Ukraine's formal legal system, under a standalone statute that could be created essentially by treaty between Ukraine and an international partner. And that has the advantage of only needing one agreement that would have its own statute, rules of procedure and evidence, criminal procedure law, which in my view should look a lot like Ukraine's national criminal procedure. And, you know, not to say that Sierra Leone, everything would have to be exactly like it was there. Any solution needs to be tailored for the needs of Ukraine and the realities here. And there's a lot of room for creativity. But I do think it's worth really interrogating the ambition of any initiative to create a court, because I think there is only one bite at the apple. If you get a standalone court on the crime of aggression, I think it might be harder to get a mechanism to fill these other gaps if that need is more recognized over time. And just finally, on this question of the ICC, because some states do have a lot of concern about competition with the ICC. There are precedents for internationalized and hybrid mechanisms that work in complement to the ICC. In the Central African Republic, for example, there's a special criminal court that has put international judges into this sort of hybrid model, and the ICC is cooperating very well with that court, and indeed with the regular justice system in that country on things like case selection and case development. So there are precedents. Any statute could make very clear that this court would defer to the ICC on case selection, would share evidence with the ICC. It could and should be a very collaborative initiative, and include a third tier, which is Ukraine's regular courts, and an ability for the three levels to kind of coordinate and decide which cases are most appropriate at which level, perhaps with a hybrid mechanism focusing on crimes against humanity cases, very complex pattern crime cases where you have to prove widespread or systematic violations pursuant to a policy, and you have to show command responsibility. These things are hard to do, and no national justice system typically has the expertise in doing those things. And so those kinds of cases could be handled by the hybrid top-level cases by the ICC, direct perpetrator type cases by the regular justice system, and over time the barrier between, or the dividing line between the hybrid mechanism and the regular justice system could fade away, and you would be left with a much stronger domestic capacity to deal with these other important gaps in addition to the crime of aggression. And it's possible to do this in a form that is international enough to get around the concerns about immunities. And I think we've seen precedent for that elsewhere.
Thank you so much, Eric. And I believe that this is very important that we were saying today about specific, actually, model indictment about initiative of the government of Ukraine on initiating the accountability mechanism for the crime of aggression, and in what way Ukrainian president can launch the chain of changes for it to be not an isolated action, but for the accountability for the crime of aggression to be something new. And Eric mentioned that we are facing very complicated tasks, and the domestic system faces a huge challenge, and the role of international community would be to use an opportunity and to strengthen this mechanisms or set this precedent. And we can actually discuss what would be the mechanism of accountability for international crimes, for us not to just have indictments, but also a capable system which can be used in the future to ensure the rule of law in the country. If to speak about accountability for the crime of aggression specifically, can we imagine that within the framework of the modeling of this hybrid mechanism, we can have a separate chamber, which would be kind of an international chamber, and it would consider accountability for the crimes of aggression specifically. And such this hybrid mechanism would be focused on the domestic system and strengthening its response to some other types of crimes. So, what would be actually the limit of designing it all? And if we create something for this very specific situation of the crime of aggression, maybe we can expand, not dealing just with crime of aggression, but some other crimes which are very difficult to handle, to have them in this hybrid mechanism. Thank you.
No, I think that's something to consider. And as I said, there's a lot of room for creativity in designing any new accountability mechanism, and it needs to be built for the purpose. And I think whatever can be done to boost the international nature of the court on these leadership crimes it is important because of the immunities question, and that could be one way to help answer that. Another way is, it would be helpful to have a General Assembly resolution, either to create the court or to call, for example, on Ukraine to enter into an agreement with the European Union to create the court. And I happen to think the European Union is very well positioned to be Ukraine's key partner in any new mechanism that's created, given its commitment to Ukraine, given the experience at the Kosovo Specialist Chambers that the European Union set up together with Kosovo. And the experience there has been, that it's been a very well run court with a lot of support from the European Union and typically less bureaucratic than UN-administered courts.
I wanted to ask, I heard David say, essentially, that it is in the self-interest of the government of Ukraine that if it wants to get a tribunal that is capable of prosecuting and trying senior leadership for crimes of aggression established in a sustainable way, one effective way of advancing the government's own cause is to ratify the Rome Statute, push for amendment to the Rome Statute on aggression to ensure, as he said, that we're not in the situation where we're creating a tribunal for aggression in this one horrific instance today that doesn't address future acts of aggression tomorrow. Now, in the short term, I can see a government saying to itself, hey, we're under siege. Our problem is to deal with what we're dealing with now. Yes, we're concerned about the future, but that's frankly not our immediate problem. We've got to do everything we can. But I heard the argument to say that the Ukraine's advocacy with international partners would be advanced if it could say to a number of partners in different parts of the world that feel as though aggression has been unaddressed in other situations, that, hey, if we create something that is sustainable to address any future situation, that will make more effective anything we do now on Ukraine. So, and yet I've heard in other contexts the notion that a tribunal may be created and it would be limited. It would be explicitly limited just to this situation because other states have concerns about the power of any precedent to deal with future acts of aggression. So I wondered if you could kind of address that tension. Thank you.
Thank you. And yeah, this question was out there in the air, and thank you for articulating it. So, yes, I now belong to the government, which is why I'm entitled to answer this question, but I'm actually not a decision maker, who deals with the Rome Statute. And I, as a Ukrainian lawyer, has got this position that, yes, we absolutely need to ratify the statute, and I don't see any legal obstacles why it can't be done. Well, maybe this is the situation when emotions overcome some rational choices. And I really want this statute to be ratified, but this is just my small voice, right? And of course, I agree with Jim, with Mr. David, that, well, international community was really giving a very difficult labor to this new notion of the crime of aggression. And actually, I don't know whether it's normal, because this is all right an international crime, as a crime of genocide, as a war crime. So whether the amendments are well needed, those to be introduced into the Rome Statute, but whether it can happen in the nearest future, I don't know. I believe that we have to be based on the paradigm that ICC won't be able to consider the crime of aggression against Ukraine in the nearest future, which is why we need to look for other mechanisms. Speaking about the next part of your question, we position the idea of the Special Tribunal as the idea of an ad hoc international tribunal. And we are speaking a lot about our partners, and we hear from them that this shall not be creation of some universal, long-lasting court, because there's ICC. And this is not a goal to do so. Of course, ICC plays a key role here, but we are speaking that the situation with the crime of aggression against Ukraine is so obvious that we need creating an ad hoc tribunal, which would give us an opportunity and which would have jurisdiction as regards this crime. Well, of course, ICC was created with this goal in mind too, for the ad hoc tribunals not to be created, but they are being created because of some practicalities, some practical issues. So on my side, I completely confirm, support efficient cooperation of Ukraine with ICC. And if we speak about accountability for the crime of aggression in the nearest future, not in 1 century and not in 55 years, then I believe that we don't have any other alternative but a tribunal. Thank you so much, Mr. Anton. And I can just confirm that we worked a lot on the issue of ratification of the Rome Statute. So I really support every word of Anton as regards the official position of Mr. Korynevych. Anton.
Yes, and I'm very sorry if I say something that might sound not nice in the ears of many colleagues, because unfortunately we live in a very difficult world And we have spent enormous amount of energy to explain to so many that what's going on in Ukraine is so serious because it implies a neighboring country trying to occupy, annex, invade, aggress, something that, almost resembled, and it's similar to what happened in World War II. So, but apart from this, and of course, the main difference between Ukraine and what's happening all over the world is that you are a democracy. So every journalist can enter, every channel can show the images. And so all over the world, we know what's going on every day in Ukraine. You are doing an enormously good work to show to the world the horrific things that are happening. The problem is that in other areas of the world, there are even more people dying because of armed conflict, because of mass atrocities. And very little happens in support of such victims. So if we want the votes, I'm referring to Syria, Yemen, Ethiopia, even Haiti. I mean, even in Haiti, there are many more civilian casualties per day of armed violence in some weeks than maybe in some weeks of this horrific war of aggression against Ukraine. So what I'm talking about here is to understand that if we need the votes of all those states for the creation of the special tribunal, and we need them because if you don't have a UN resolution, you don't have a properly international tribunal. You may have a regional court, but that may not be good enough for the standards of the ICJ on the no immunity principle. Whether we like it or not, we need a universal body, and that universal body, in the absence of the Security Council failing to perform its duties, it's only the General Assembly. So we need more than 100 votes at the General Assembly. We need to be realistic. So we need to have to design a pathway towards justice for all the victims of mass atrocities, and the Rome Statute allows that if a state wants, in terms of genocide, crimes against humanity, and crimes of aggression. And we need to tell those states, and by the way, by creating this special tribunal, we commit to end impunity for every future aggression. And we can do it with the ICC because we have an amendment. Vote for it, it's going to pass, ratify it, it enters into force, and in the next aggression, we will have the ICC to deal with it. It can be done in a few months or a few years, but immediately we can create the tribunal. So that is my strategic approach. And we need to live in this world in which we are, where we have so many suffering, so many atrocities, thousands of civilians killed every day in a lot of corners of the world where, since they are not democratic countries, we cannot see it on TV, but it's happening. So in order to gain the consent, and why only 43 states ratified the amendments on the crime of aggression, which is something that Jim said before, because these amendments don't protect against aggressive states and nationals who are citizens of states that are not parties. So by staying out of the system cannot catch you. This was, unfortunately, the view of the United States of America. Wrong view, now negated by bipartisan resolutions in the Senate and the House of Representatives. And things are changing in the United States. The main member of Parliamentarians for Global Action, Jim McGovern, is the author of a resolution calling for the ratification of the Rome Statute by the United States. Things are going to change sooner or later. But we need to make sure that this message goes up to the top. That, your president, and I cannot do it, I don't know him, but maybe some of you know the president, tell him there's no risk in joining the ICC, because somebody must have said to him, including probably Mr. John Bolton and other luminaries that made the big mistakes in the past, that, if you join these, it's bad, this is a corrupt court, this is a bad man in charge of it, or a bad woman. You have seen Mr. Khan is not a bad man at all. So I think, and in fact, the position of Parliamentarians for Global Action, and here I can share another minority position, is that once this tribunal is set up, the prosecutor of the ICC should be appointed as the chief barrister in charge of bringing the indictment in front of this tribunal. So there is no problem. Even the same prosecutor can present the case, maybe not perform the role functionally as prosecutor, but as the one presenting the case in the courtroom. He has the qualifications to do so. So there are many ways and means to make this special tribunal being integrated in the system, because our experience in these months is that so many people are saying, why do we need this court? We have already the ICC. So we need to persuade them that this court is not detracting anything from the ICC.
No, I have a question, sorry. I want us to go back from this higher politics to this model indictment. And I have a question about it, a specific one. Maybe it's a simple question, right? So, we saw 2022. We believe the aggression of the Russian Federation started in 2014, not 22. And this is the issue of resources. Yuriy Belousov will be dealing with the resources. So, maybe you have some thoughts that in 2014 it differed a bit from what happened in 2022. Well, actually, we are going to take a round of questions now, and then we will give the floor to our panelists, 1 minute each. But it was a question to Yuriy Belousov, I believe, right? So, yes, Mr. Arkady, I'll answer more later, but the words of Eric about hybrid wars, which were there in other countries, and that they incorporated actually international judges, and that some international separate institutions were created. That's interesting. And for me, it shows me that Ukraine is a bit different from other countries. Not that just we are better, though it's so. But the situation is very different compared to those countries where these models were introduced. Crimes against humanity were committed by the leadership of the country, and actually in those countries there were no proper judiciary systems in place. So I believe the approaches which were applicable towards Ukraine starting from the beginning of 2022, meaning from February, they were based on the existing experience that in Ukraine there was no capable judiciary system and it's not legitimate enough, which is why we need some additional mechanism. And it had very negative consequences for the judiciary system of Ukraine, because it's obviously a lack of trust, right? And those who were documenting crimes of war, they were oriented at international institutions, at ICC, which is getting thousands of cases from Ukraine, and they can't work on those properly now. And yeah, we keep on directing all these cases towards ICC. So in this context, I'd like to mention that we should have some different approaches to creation of these accountability mechanisms for Ukraine, because we have a capable domestic system which will just be supported by experts. We do not expect that somebody will come and do everything instead of our judges, our prosecutors, our investigators. No, because we're speaking about thousands and thousands of crimes. So I don't want our domestic system to be perceived as not capable at all. I believe we need to just support this system, and we need to get some practical pieces of advice, and this can bring our existing system to a higher, better level, which can ensure actually the accountability. Thank you, Yuriy. And when we do the analysis, of course, a lot of things shall be taken into account. And there's another complicated element. This is a current conflict, and we are party to this conflict. And it's a very important challenge, very difficult challenge for our domestic system. So we need to understand what would be the model we will follow when answering and dealing with this challenge. We need to show the international community that we actually can legitimately deal with these crimes. I saw other hands in the room, please.
It is definitely true that Ukrainian justice system is being actively involved in the processes. It's not completely incapable. It is facing a lot of challenges. But it also seems that, and I do think that the final answer to this question would be somewhere where we assess the actual needs of all of the stakeholders involved, all of the stakeholders that are actually dealing with all of those crimes on all the levels, the investigative, the prosecutorial, the judicial level. And I don't think that that we will be able to resolve this dispute in terms of how far capable the system is up until we have this certain answer from the the assessment in general. But it is very likely, at least from our perspective, as we are analyzing the judicial system in Ukraine and the conflict in general, that the system will need help beyond the general training, beyond the general advice, such as, for example, the internationalized mechanisms, as, for example, Eric is suggesting. And my question here would be, is that given that in general, special mechanisms are a big challenge for the international community to establish in the first place, wouldn't it be a threat or a danger for the efforts to ensure accountability for war crimes, for crimes against humanity, or maybe genocide or incitement of genocide, if we have the respective case, if there is only a tribunal for crime of aggression established, and whether it might undermine all the possible efforts to establish any other special mechanism, because it seems to me that it might be an issue and that the community might be very, very reluctant to establish multiple mechanisms for all of the possible crimes. So wouldn't it be a possible alternative to have a mechanism that would be mandated to deal with all of the crimes, including the crime of aggression, so that it is internationalized enough so that it is legitimate, as the speakers were pointing out, and that it is capable of dealing with all of those crimes and in kind of strengthening the domestic system as one of its purposes. So that's probably the question that I would like to throw in the air, and would very appreciate any answers to. Thank you.
Crimes of aggression are missing in the Ukrainian legislation, and we can rely on international mechanisms, as ICC in particular. I have certain takeaways. I would like to say something about the prospects for future. If we opt for the Nuremberg or Tokyo solution, because this is something that has been done before, victor's justice. Is this a solution? Well, it's the most realistic. Victor's justice is the most realistic, but we need to wait when it's possible to do it. As far as I understand, ICC is not the best solution. So virtually what we are talking about is a special tribunal for Ukraine. But wouldn't impartiality be a concern? So it means that it matters who will be as judges. So impartiality of this new structure, and as far as I understand, this will be a hybrid model, and impartiality for this tribunal will be provided when the autocratic regimes in Belarus and Russia fall, in order for the opposing party to be able to send their judges to this court, to have two parties represented. And there's one more thing that was mentioned today, that the Russian soldiers that are sent to war, they're also victims of the crime of aggression. Russian citizens are victims of this aggression to some extent. So this means, this brings us to the issue of composition of the court. Now it's our opportunity to conclude our meeting, and now I would like to give the floor to our speakers, and let's start in the same order as we began. Jim?
Great. Well, thank you so much. This has been really a rich and such an important discussion. And again, the fact that it is taking place here in Kyiv at this very moment is so significant. I guess two comments. So one, there was a question raised about whether one could extend the timeline back of the indictment, the model indictment, back to 2014, which I suppose in principle one could. One would have questions about gravity and scale, it seems to me, among other things. Our goal was not to say that we are producing the definitive document, rather that we wanted to show what is doable relatively quickly and compellingly now, with respect to the events that, in my view, are indisputably satisfactory, constitute the crime of aggression. But, where a tribunal lands, and I'd be very interested to hear from Anton and others where the various discussions stand with respect to extending the timeline further back. One other comment, if I may, Roman, just on these questions about different kinds of mixing national and international elements, and what the scope of the jurisdiction should be of any kind of a tribunal. We're talking about, as has been said, both legal considerations and political considerations. We all live in the real world, and those of you here know that better than most of us right now. So one is constantly trying to balance the ideal and the achievable. It seems to me, there are various aims that one can think about for what one wants to achieve from where we are right now. For some people, it seems to me, I've heard them say, the most important thing 10 years from now is that the most responsible party, President Putin, be held to account for something. I don't care what. I want him held to account. For other people, it seems to me, because this is the most blatant and flagrant act of aggression we have seen, it is most important that the act of aggression and the crime of aggression itself be punished. That is the most important thing. For other people, I've heard it during my visit here in Kiev, it is most important to a number of the victims of these horrific crimes that are taking place that they're direct perpetrators, those who have shot or tortured or executed their loved ones, that those individual perpetrators be held to account. That is most important for them. And for other people, I suppose, it is most important that 10 years from now, Ukraine have an extremely well-functioning judicial system and criminal justice system that is capable of processing these kinds of crimes in a fair and effective way. So there are different aims. Some of them can be aligned. I think one needs to consider what is most important and what is politically possible, and that will probably guide where one ends up in respect of the particular kind of tribunal that we land with. Thank you.
Thank you very much for the discussion. This has been a very productive discussion. I can't speak for everyone, but I believe it's self-explanatory for everyone here that there has to be accountability for crime of aggression, and a new mechanism needs to be introduced. Yes, there are a lot of issues. Some of them were mentioned, in particular that there was no accountability for crime crime of aggression after Tokyo and Nuremberg, because there was accountability for crimes against peace. And actually, I have to mention here that a Soviet lawyer offered this phrase, crimes against peace. Okay, so there are issues, but there is nothing we cannot well, we can handle that. And individual accountability, individual responsibility is important. So specific people need to be held accountable. Another point that I wanted to make, something I wrote down. The aggression of the Russian Federation began in February 2014. So there's aggression and full-scale invasions. So that is why 2014 was mentioned as one of the suggestions. And there was a document passed by the Parliament very recently about the Special Tribunal, and this time is exactly used there. Regarding impartiality of the court and the composition of the court, of course, some people would say that Russian judges need to be on board and part of this court, but we live in real life, and impartiality could be specified in some charter documents. For example, there could be an advisory panel set up that would select the judges, the advisory panel that would engage the highly respected experts in the area of international criminal law. We already have that. Thank you. Thank you very much. David, over to you.
On this specific point, it has really to be an international law, source of law, not a domestic law. So at the end of the day, we can have so many international judges, hybrids, and so on, but it would not overcome the fact that it wouldn't be a properly constituted and competent international tribunal as defined in the International Court of Justice judgment that, whether we like it or not, is being seen as the one crystallizing a customary international understanding of where immunities applies or not. So I think in this respect, of course, if this tribunal has to judge the ongoing aggression, I think it has to include the international judges, because, of course, any Ukrainian is a victim of the crime of aggression. So I think, it would be just a matter of reasonableness not to have any Ukrainians as a judge and so on. So I think I totally agree. It has to be an international tribunal. There is no shortcut. Of course, other mechanisms to support the Ukrainian judiciary are absolutely an excellent idea. I cannot imagine my own country dealing with 34,000 incidents of alleged war crimes. I'm talking about my own country, Italy. I cannot even imagine. I know that our friends from a Tribunal for Putin coalition of NGOs led by the Center for Civil Liberties and the Kharkiv Center for Human Rights and others, they have collected materials that may become evidence of 18,000 incidents that may be qualified as war crimes or crimes against humanity, or in Mariupol, even in my view, genocide. So how can even the German legal system would collapse in the front of this mass of evidence? So it's clear that something needs to be done to support and strengthen the domestic capability of Ukraine, as it was necessary if it would have happened in Germany, Italy, France, or I don't know, the United States. I don't want to say anything here because Jim here is the authority. So I think it's a huge job, and nothing excludes the other. The only problem that we are facing is that some of our states or world leaders or colleagues in the NGO world or academics or think tanks, they believe that, like in Syria, like in, Georgia, like in respect of Chechnya, like in respect of other situation of mass atrocity crimes, The way to move forward and bring about peace is to find a deal, to cut a deal with the criminal. Again, if we wanted peace in the 1980s in Sicily, we would have done an agreement with the mafia. They would have ruled the economy and there would be no people killed by the mafia, of course. So, we need to think in this perspective. In this perspective, there is no peace when at the highest level of command, there is an individual who is self-incriminating himself every day, and especially that's the difference of the 24th of February. I think that speech. So I would not mix up the jurisdiction of a tribunal, which can go back to 2014, to the Model Indictment. The Open Society Justice Initiative did the right thing. They just took the immediate evidence suddenly available and make it a case. That was a perfect project, and we should not mix up the two. You can still have a jurisdiction starting from 2014, but I would make the case of the full-scale invasion. Why? Because the evidence is publicly available. You can have the case tomorrow. So I think it's also very important to be strategic and make sure that what we do is immediately workable. And I think this is why this project that Jim and his team has been bringing about is so important. And I think that we need to illustrate this argument most forcefully with Mr. Guterres, with other leaders, because I have the feeling that there is still in the back of the mind of those who negotiate that, we can cut a deal. Honestly, with this nuclear threat and other things that are going on, honestly, I have very, very big difficulty in identifying the margins for such a deal. Thank you.
I don't have a lot to add. Maybe just that, we've talked about different models today, and I just want to underscore that there have been, dozens of other international justice experiences around the world. And I don't think anybody's suggesting that you just take one of those previous experiences and try to apply it here. There does need, I think, to be a needs assessment for what Ukraine needs. We need to tailor the solution for Ukraine, but at the same time, keep an eye out for international legitimacy and consistency. So Russia's attack on Ukraine was also an attack on the international system. It was a frontal assault on the UN Charter, on the rules-based order, on multilateral institutions. How do we build up a system of international criminal justice? And this is a question facing all of us. How do we build up a system of international criminal justice that is not only best suited to meet the needs of Ukraine in this moment, but to meet the needs of others around the world who are experiencing atrocity as we speak, as David mentioned, and victims into the future in a more consistent way that is not just responsive to global powers with special protections for the most powerful states? How do we build a system that's more equitable and more robust? And by the way, in becoming an advocate for that, I think you can help build the support you need now in the General Assembly among states who frankly often wonder, why so much attention to Ukraine? What about us? What about our suffering? We're not in the news, but we're suffering, and there's real resentment there. So it's a massive challenge, for a country under full-scale attack for all these months to have to think about this too, and it's a testament. I think your ability to reckon with all of the complexities we've discussed tonight, your presence here, this discussion, is really admirable, and I'm really grateful that you've come out to wrestle with these questions, and you have our full support. Anything we can do to be helpful, to share what other experiences may teach about what may or may not work for Ukraine. Yeah, be grateful.
Thank you very much. On more than one occasion today, we heard this phrase that we live in a real world, and this is the real world is something that we have to return to after this highly intellectual discussion. And actually, it's a miracle that we haven't had a single air raid siren during our discussion, but that is the reality that we live in. The reality that million Ukrainians living in, the reality of air raid sirens, the reality of war losses, and this is happening as a result of the armed aggression of the Russian Federation against Ukraine. And it goes without saying that we are very much interested to have our intellectual discussions to make the accountability for the perpetrators possible with use of documents like this model indictment. We started our discussion with this document, and I would like to thank the Open Society Justice Initiative for assisting and actually visualizing a lot of discussions in this document. And I would like to thank the Just Talk team who worked hard to make sure our discussion happens despite what is happening. Thank you very much, and see you next time.